SJC-11277, Commonwealth v. Moody and Newman.
All right, let's proceed. Good morning.
Good morning, Your Honors. May it please the Court. For the record, my name is Timothy Farris, and I represent Mr. Devin Newman. We're going to divide up our argument this morning. I'm going to address the statutory construction issues that I believe are raised in this case. My brother, counsel, is going to address some of the case law points as well as the issues raised in the Commonwealth's brief. Your Honors, the issue that's presented here is one of statutory construction, and whether or not the Mass statute, which has not been modified according to the federal statute, permits the intercept of cellular phone records and cellular phone communication, Your Honor, in the form of verbal communication as well as text messages. And the argument that we're making is that Massachusetts is one of 3 states that has not changed its statute, 27299, in conformity with the federal statute. The other 3 states being, or the other 2 being North Dakota and New Mexico.
Could I ask you to clarify something from the very beginning that I was confused about? There's reference in all the briefs to whether the federal or the state statute is more or less restrictive, one of the or the other. And so if, for example, cell phone communications are not within a defined term, they don't fall under wire communication or they don't fall under oral communication into the statute, I'm not sure what that means. Does it that it's all right to intercept them even without a warrant because they're not in a protected category, or that no warrant can ever cover them so they can't be intercepted at all at any time? I see what I mean? I don't understand what's the starting point is. Is it that the statute protects certain kinds of communication by including them within the definition, and if they're not within the definition, you don't need a warrant, you can just go after them because they're not protected communications, or the contrary? Could you help me?
Well, I believe in looking at the federal statute, and I think that the federal statute gives greater protection for individual privacy rights than does 27299. And so the cell phone communication under the federal statute affords that greater level of protection. And
how? By including the certain kinds of communications within the category?
Yes, which then requires the formal, and I wouldn't call it a warrant, but it's the federal intercept, where they have the permission from the court to be able to do the intercept. It's not a warrant in terms of the 276 warrant that we address, so it's not quite the same. It's an intercept.
But I assume that argument has gone away since 1988, since the federal government gave the states 2 years to live under what may be more generous standards with regard to that which is within the federal statute.
And that 2-year, yes, and that 2-year time period having expired presents the issue that the state, in this instance, cannot utilize the intercept under 272.
If I can go back sort of to basics, 1968, a telephone call was a telephone call. It was referred to as wire communications because at that time that was what people understood to be how telephone calls were communicated.
Yes.
Why should we imagine that the legislature, as the technology changed, did not still wish to cover voice telephone calls?
Well, the legislature may have wished to cover voice telephone calls, but what we have here technologically is not a voice telephone call. And since it's not a voice telephone call, it's digital. If it's a digital...
You say it's not a voice telephone call. I speak on my cell phone to my spouse. She hears my voice at the other end. It may not go through a wire, but it's still a telephone call.
And if I could address that issue, from a technological standpoint. I'd refer to the affidavit of Michael Verno, paragraphs 2, 3, and 9, to quote, "When a cellular phone caller speaks into his or her phone, the cellular phone uses software to convert the analog audio into digital data in binary code, known as pulse code modulation."
But the old wire system could have done the same thing too, couldn't it? Couldn't they, by computer, have converted a wave-modulated signal into a digital signal?
They may. I don't know the answer to that, Your Honor. They may have been able to, but in this instance, that is what is done as a function of cell phone technology. I think that's why, and at the time that the federal statute was amended in '86, we still had analog communication with cell phones. Now we have digital communication.
Could I just go to the '86 statute? I appreciate what you're saying, and that may prevail ultimately, but the Senate report and the House reports both are pretty clear on this issue, that the wire communications were intended and to cover the cellular telephone situation, according at least to the stuff that the Attorney General has pointed our attention to. And looking at that, and they furthermore state that with respect to the states that, like Massachusetts, that haven't changed, that some states may not need to. New Jersey didn't, very similar statute to ours, and you don't really address that. What do you do with this very clear, arguably clear legislative history that says we're covered already, we're just clarifying?
I disagree with that premise, Your Honor, that we're covered. I think that what the federal statute did was they wanted to make sure that it was clear and that it was covered. And I would agree that you're right, that under the federal statute, in terms of how it's drafted, it is covered, cell phone communication is covered under wire communication. But that's because of the drafting in the federal statute.
You're saying it's because of the additional switching language.
Well, I'm saying the additional language that's included in the federal statute, if we look at 2510 in the definitions A through B, it adds the language oral, A-U-R-A-L, communication before the term wire. And it adds the additional term defining oral communication, A-U-R-A-L. It defines that. It also defines electronic communication. So the argument would be that if it's not a wire communication under the federal statute, then it's an electronic communication, and in either event, it's covered under the federal statute, which the state statute does not control.
The Commonwealth says that the state statute does, that when you trace a cellular telephone call, there is a point in time in which it passes through wires. Either it gets to a landline or in any event, at least that's how I understood it. So what do you say to that?
Well, the Commonwealth says that. However, I would indicate also in the legislative history of the federal statute, it says that it is intended to refer to a wire that carries the communication to a significant extent from the point of origin to the point of reception. It does not refer to the wire that is found inside the terminal equipment at either end of the communication.
That's the federal statute.
Yes.
Well, but we don't have the federal statute.
I understand that, and that's so that argument that it is in fact a wire communication, I don't believe under the legislative history of the federal statute gives the Commonwealth the ability to intercept it at that point, because that's not what the central force is. To go back to the original question in terms of what was the original technology, it was carried over the wire. And here we don't have that. It's not carried over a wire. And that's not what the
point in time? No wire at all?
At least under the evidence that's before the court, I would suggest no. There is no evidence that indicates that there is any wire communication under the, at least under the affidavit that's been presented.
Under the legislative history, both reports in the House and the Senate refer to the fact that there is at some point, which occurs during the connection in a switching station, which is a language they inserted under wire communication in 1986, that there is when you at times need a wire. And so they added that language according to the reports in the wire communication section to include cellular telephone communication. They added the electronics for emails. According to the reports, are you saying that that's just not the case?
No, I'm not saying that. I'm saying that, again, what the intent of it is that the wire communication is not to include the wires that were involved in the switching. And that's why they added the additional language of oral in terms of the definition of wire communication. And the legislative history talks about that, Your Honor. And they clearly said in the language I just quoted a few moments ago from the legislative history, it does not refer to the wire that is found inside the terminal equipment at either end of the communication. And that is out of the legislative history from the federal statute.
Mr. Ferris.
I'm sorry.
I'm sorry, your time is up.
Thank you, Your Honors.
Good morning, Your Honors. Edmund St. John for the defendant, Corey Moody. Your Honors, the 1986 enactment of the Electronics Communication Privacy Act, at least the Commonwealth is arguing that it merely clarified that cell phones were wire communications. We would submit to you that there really isn't any authority of any cases pre the 1986 Act, which would indicate that cell phones were considered wire communications.
Well, I mean, they, of course, weren't considered in 1968, where a legislature may be wise, but I don't think anybody anticipated that. But what meaning do you give to the phrase, or other like connection?
Other like
by
connection.
the aid of wire, cable, or other like connection. What does the like mean?
The like means, Your Honor, I would submit that the communication would have to be transmitted over wire or cable, not wireless. We're dealing here with...
Doesn't that then eliminate the need for that phrase? I mean, you're saying then that it's essentially adds nothing to wire or cable, but that is not in keeping with our usual interpretation of statutes that every word and phrase means something.
I understand that, Your Honor. Your Honor, I think in a case like this where we have impacted here very important privacy rights as well as a statute which is a criminal statute, we have to give strict construction to the statute.
But this criminal part of the statute protects the, really protects against not having this done without the proper, it prosecutes people who do this without going through the right steps, correct?
It does, Your Honor, but one of the problems with the 1968 statute now is that the prosecution of someone who unlawfully intercepts a cellular telephone conversation is perhaps in doubt. I mean, when we go back and look at cases like the U.S. Supreme Court case that we cited in our brief, Bartnicki versus Vopper, that indicates back then that the Supreme Court was very concerned that the 1968 enactment would not cover radio transmissions or possibly cellular telephone conversations.
So let me ask you this. I think I'm clear on this, but this interception of cellular calls and texts that we have right here does not violate federal law, does it? It does not violate federal law. A warrant was obtained that would have been adequate under federal law?
If a warrant was obtained from a federal district court judge or magistrate, it probably would have satisfied the federal statute.
Okay.
But the warrant here in this case was obtained from a Massachusetts Superior Court judge who was following the 1968 enactment, which our contention is does not extend to this type of activity.
You're saying this does violate federal law?
No.
Done here violates federal law.
I'm not saying that this violates federal law. I'm saying that this violates the statute under which it was enacted. Massachusetts 272, Section 99.
Do you know why the radio communications were not encompassed by the original by 272.99?
I don't have an answer as to why that's the case, but I would say to you that a case like Bartnicki versus Vopper threw that a lot of doubt onto whether it could be covered under 272.99 or the federal equivalent at that time.
But wasn't it because the radio signals were open to anybody that could build a receiver that could I mean, it was sort of like a wave, an airwave that was open to public inspection. Anybody could listen in on it. You didn't need, all you needed was like a crystal radio that you'd built in the Cub Scouts or Girl Scouts.
That is correct, Judge.
Can I ask you, is it clear that text messages under the federal statute are considered electronic communications and not wire communications?
It would appear that under the federal statute, text communications would be considered electronic communications. In our argument, we've extended the argument that the electronic communications would also encompass cellular telephone conversations because of the manner in which those are communicated.
Right, but federal case law construes the federal statute how with respect to cell phone? Is it not wire communications?
It is considered, cell phone calls, telephone conversation are considered wire communications because of the 1986 amendment.
Right, but under the 1986 amendment as well, I'm not even sure when text messaging became available. Do you have any idea on when we're talking about that technology being something that is accessible?
I don't, Your Honor.
So we don't really know what time period. Would it have been as of 86, do you think?
I would say no, because I think it was more to address something like electronic mail. Email, which was becoming more prevalent at that time.
But there are decisions that you say that categorize text messages as electronic communications under the Federal Act, under the 86 Act.
I'm not aware of any decisions. I would assume that they would be covered under the Federal Act.
Let's assume for the moment that text messages fall outside the 1968 Act. Many things fall outside the 1968 Act, but we still permit search warrants for them. GPS devices on cars, we said we applied a common law warrant. Would there not be any common law warrant that would permit text messages, and if it's done in a manner that would meet the federal standard, would it still survive?
I would say, Your Honor, that there isn't any at this point, and that would be, again, because this is a field that has traditionally been legislated, the subject of legislation. There is currently even a bill pending before our own state legislature that apparently hasn't gone out of committee yet that deals with this. But because of the rights that are impacted here, because of the fact that it criminalizes certain behavior, I would suggest to you that that would not be the case.
So, but getting back to Justice Lenk's question to Mr. Ferris at the very beginning of oral argument, if cellular phone calls are not covered, rather than have nothing cover cellular phone calls, why isn't the default position the common law warrant?
Well, Your Honor, again, I refer back again to the very important privacy interests that are at stake here. There has to be something in place here that would protect the privacy interests. We have a case called Commonwealth versus Vitello, which was alluded to earlier in terms of the protective nature. Is the Massachusetts statute, is common law less protective of the federal statute as far as privacy interests are concerned? If it is, then it would fail because of the preemptive effect of the federal law. So if we had a common law, application to this, or if we used our own statute, if we are somehow less protective of privacy interests, we are going to fail in the face of that.
But if, as you said, I think in response to Justice Gantz, that this would satisfy the federal law because it covers cellular telephones, why would preemption be a problem if you had a proper common law warrant?
I would submit to you that it would be a problem simply because the common law warrant would be less protective. I don't know exactly how one would be able to draft a common law warrant that would be able to meet the federal standards in the face of preemption.
Why is that so? Because a federal magistrate would have to approve it? I mean, why?
I would submit to you that a federal magistrate in this instance would have to approve this type of warrant. This could have easily been brought to the attention of a federal magistrate. There's something that is in place right now.
Well, counsel, we'll have to leave it there. Thank you.
Thank you, Judge.
Good morning, members of the court, honorable justices. For the record, my name is Joseph Piropan, Assistant District Attorney for the Berkshire District. Justice Lenk, I'm going to answer your question directly. It's going to be a long answer. Please give me some latitude here. If indeed this court were to find that the cellular communications fall outside of 272.99, then this court may clearly rely upon the common law and constitutional applications to find that the warrant issued by the Superior Court in this case satisfied Article 14 and the Fourth Amendment. I have two cases I want to bring to the court's attention. Number one, Commonwealth versus Penta. Unfortunately, it's not in my brief. I found it at 6 o'clock last night. But nonetheless, it's a case that it's 423 Mass 546. This is a rather odd case. This is the case in which this court held that a search warrant issued pursuant to 276.1 and together with the dictates of Commonwealth versus Blood, 400 Mass 61, authorized the recording of one-party consent communications recorded by an undercover police officer as the officer dealt at arm's length with a drug dealer, I believe. And the court in that case found significant that that communication was specifically exempted under 272.99. In other words, it was one of those communications that did not require a 272.99 warrant. But the court said significantly, these communications are protected. And the default position then is to fashion a remedy or a procedure under Article 14. And that's exactly what this court did in Commonwealth versus Conley, the GPS case. And in Conley, I wish to focus upon Judge Gantz's concurrent opinion, in which I believe the spirit of the Katz decision is at play here. The Fourth Amendment protects people, not places. Here, the 272.99, I would submit, in conjunction with the common law in Article 14, wants to protect conversations, communications, over which persons have an expectation of privacy that courts will recognize as being reasonable. Likewise, in the GPS context, this court found it to be a trespass to attach the GPS device to the car. Justice Gantz, in concurrent opinion, said even more significant is the fact that when you drive your car around, you don't expect Big Brother to be watching you from afar. Similarly here, we don't expect people to be listening to us from afar. And in 1968, when both the states and the federal government enacted the wiretap statute, wiretapping was the evil. It was because we wanted to prohibit the surreptitious, secret, unauthorized monitoring of these communications. Now, we use the term wireless. You know what I find significant? I went to the Titanic Museum 2 years ago, and they boasted the fact that Titanic had a wireless device. That's 1912. Certainly in 1968, the Supreme Court and this court and every other court knew that wireless communications existed. So here we go. What did this legislature mean when they described or defined wire communications as that being conducted over wire, cable, or other like means?
But you do argue that wire is involved in this transmission at some point, don't you?
Clearly we do, Your Honors. Your Honor, I'm sorry, yes.
Are you giving up on that?
No, absolutely not. I'm still arguing my...
Where is it? Where, at what point in the traveling of this communication does
Well, how big is a wire, Your Honor? Is it a foot? Is it 1/16 of an inch? Is it within that little transistor within the cell phone? I find it significant that the definition is wire, cable, or other like. Isn't a wire a cable? Now, at the motion to suppress hearing on page 34 of the volume, Mr. Ferris quite capably argued on behalf of his client that, and I'll quote Mr. Ferris, he's quotable, page 34, a text message is an electronic communication being sent over the cellular telephone tower. It's not a cable TV wire. I understand that the coaxial cable that comes into your house is perhaps different than the little tiny cable that connects to your telephone. But where do we draw the line?
Are there any wires left inside cellular phones? Is that in the record?
That's not in the record. But what is in the record is the fact that cellular communications use these cellular towers. And that's significant because, as Mr. Ferris noted, these cellular towers are mammoth structures containing electronic components. I use the word electronic to mean transistors, other similar methods of communication. My point is simply this. Whether you're talking about Alexander Graham Bell uttering it into a ancient device or a modern cell phone using digital technology as opposed to analog, there's a transformation of the speech voice into an electronic image that at the other end is recognized as the caller's voice. That has always been the case. There's always been this transformation over a wire or some other medium of the voice from point A to point
Well,
B.
would you agree that it would have been so much easier if the legislature had just said including cell phone communications?
Well, Your Honor, that's my next point, and it's sort of a subset of my response to Justice Lenk. We cannot read into the legislature's inaction a like or dislike of the present law, and that's the Dillon case that this Court very ably cited in 2000. And I'm going to quote the language. The peculiarities of the legislative process furnish many reasons for the lack of success of a measure other than legislative dislike for the principle involved in the legislation. It would be speculative for this Court or for anybody to presume why the legislature did or did not act.
Okay, but it's not speculative to understand what the legislature did do in 1968. And is there any reason to think that the legislature would have expected that this would include communication in writing as opposed to voice communication?
Well, would that include telegrams and telegraphs?
Are telegrams and telegraphs viewed within the Massachusetts statute? I don't know.
Telegraphs are actually specifically named in Section 99, together with telephones. My point is simply this: the mode of communication is less important than the expectation of privacy in the communication. We are protecting content. We are protecting people's thoughts. We are not so much protecting whether or not you use a digital keyboard, a old-fashioned Morse, telegraph, or some other instrument, which, by the way, in the 1960s was deemed to have used a wire at some point in time. I'm sure the Titanic used a wire to send messages across the North Atlantic, signaling for help. I'm sure that in 1844, when Samuel F.B. Morse sat in the chambers of the Supreme Court in the old Capitol in Washington and sent the message, "What hath God wrought?" The Supreme Court in 1844 knew there's a wire involved there. The point is, if you go back to the definition between oral and wire communication, I truly think that the legislature was seeking to protect speech from the mouth, directly from the mouth and overheard, either by use of a bug, as in the case of cats, and the bug was outside the telephone booth, or in the more common case of using an intercepting device to surreptitiously, unknowingly, unseeingly, and secretly monitoring that conversation.
So are you just basically saying, Mr. Puripan, that it is really, this case is really not about the nature of the communication, not about the manner of transmission of the communication so much as it is about the nature of the communication?
Yes, and more to the point, Justice Lenk, I was going to start out with this, but as the Court can divine from the Commonwealth's brief and from the very excellent Attorney General's amicus brief, the statute that has been alive in this Commonwealth since 1968 is very broadly written. Unlike the federal statute that unfortunately has been scrutinized by the legislature to include a number of technologies that will become obsolete as soon as legislation is enabled. Our statute defines wire communications as any communication. It defines oral communications as speech. It is the intent of the legislature, and I believe it is with the blessing of the courts, that we are protecting speech as you hear me from 20 feet away, or as you hear me on my cell phone from 200 miles away. And for that reason, the Commonwealth would submit that the statute, as written, certainly includes all types of communications over which persons have an expectation of privacy. Unless the Court has further questions, I'll rest upon my brief.
No, we do. You mentioned,
I know we can get away that
you mentioned
fast.
that the word telegram is included in
Yes.
Section 99.
Yes.
Where?
A moment, please, Your Honor.
And do we have any cases which involved the use of Section 99 with regard to written technology back then, which would include, I would think, teletypes, telegrams?
I believe it's in Section F, Your Honor. I'm in my addendum at the present time. It's application. It's a Commonwealth's addendum, page 12. Specifically, it's Section F2C, describing the place in premises over the particularly described telephone or telegraph lines. So the words telegraph and telephone were specifically used in the warrant application requirements.
All right. That's the only time, I gather, that it's mentioned.
In my very quick perusal about 10 minutes ago,
And
yes.
do we have any case in which telegraphs were overheard using Section 99?
Unfortunately, I do not have any telegraph cases, Your Honor.
Okay. And going back to your question with regard to Justice Lenk, I mean, we have said that telephone communications that do not involve organized crime do not fall within Section 99. Is it your view that they could still, that the Commonwealth could still do a wiretap on them under the common law because it would fall outside of the scope of the statute but would still be permissible under the common law?
So, all right, so let me think this through. What the court is asking is if in fact we have a telephone, we'll call it a landline communication, just keep it safe.
Let's keep it traditional.
Keep it traditional.
The point is,
yes.
You had suggested that what falls outside the set of communications covered by Section 99 could still be overheard as long as you met the procedures in Section 99 and were in compliance with Article 14.
Well, my gut instinct is to say that if indeed a traditional telephone conversation is not considered organized crime, and so it falls outside the scope of the existing statute, then no Section 99 warrant can be obtained. And then B, I would submit, because the statute specifically says those communications cannot be intercepted, the police could not apply for 276-1 warrant. Justice Lenk said, what happens if we find that these communications aren't even covered at all by 272-99? In other words, it's a distinction not between the content, but between the actual form of communication, whether it be cellular, wire, or traditional. And so that's how I would answer that question, Your Honor.
I understand that we can't be in the business of trying to figure out why the legislature hasn't acted, but I didn't realize until Mr. Farris said it that we were only one of, I think he said 2 states. Is that right? 2 states that had made no amendment after 86. Is there any indication that before now, I mean, between 86 and now, I know right now, but near 86 or in the 90s that people tried, or just blank? Do you know?
Tried to amend the statute, Your Honor?
Yeah.
I can only offer an educated guess that I believe there have been attempts. I do not know exactly when those attempts were made.
But you think there have been attempts, just nothing's ever materialized?
That's my best answer to that.
And is it also your view that if you are right, this would cover emails from a smartphone as well as texts or any other
Yes, because those are any communications.
So this would cover everything that a smartphone can do that communicates with another?
Yes, because anything that qualifies as a communication. And for that reason, I would ask the Court to agree with the Commonwealth that Judge Ford too narrowly read the term wire communication to only include oral, AURAL transfers, because that would actually be contrary to the clear language which would include telegraph communications, which are not oral.
He was focusing on the use on the definition of interception.
Yes.
Which speaks of to secretly hear and secretly record.
And he negated the he found that the because the word secretly here came first before secretly record, that meant that it had to be oral, a URAL communication. However, if you continue reading along the definition of interception, it indicates that, and if I may just go to my appendix quickly again, please. I beg your patience. The definition of the word interception specifically says to secretly hear, secretly record, or aid another to secretly hear or secretly record the contents of any wire or oral communication. It doesn't say the speech or the voice, but it says the contents. And so, again, the Commonwealth's position is we're protecting the contents, whether they be oral, digital, email, instant messages, etc.
All right, thank you very much.
Thank you very much for your time, Your
We'll take
Honors.
a brief recess.